Hi, Mark. This is Piri. Has the meeting started? Hello?
I also have a question. As I understand it, the footprint of the building did not change. The expansion took place within the existing building footprint. Is that correct?
That is correct, Kathy. The facility, the marijuana dispensary, operates within an existing building. They were proposing to expand their use area essentially into an existing suite or second part of the building. So the proposal was for construction improvements on the interior of the existing building.
And I wasn't able to really understand whether the expansion had already been completed or not.
It has not been completed. So in the staff report, you will see some reference to information about vested rights. It explains there were 2 permits that were originally applied for as part of the at the site of the dispensary. The first one was for some work on an interior staircase. That was approved. It was not part of the expansion. And the second permit was for a proposed expansion of the facility that was not approved and not issued, and was denied 3 times on multiple review cycles by the zoning review staff because the compliance portion, the zoning compliance, had not been complete and had been denied ultimately.
So the implication then, if we were to deny the request for the expansion, the downtown dispensary would still continue to operate. Is that not correct?
That is correct. We're not questioning the operations of the
just wouldn't be
facility.
able to use that existing vacant space.
That's correct. The subject of the determination is the definition
So
of
it
the
will
school as it applies to the expansion only.
So then this marijuana dispensary will continue to from the tile works.
That is correct.
So just to be clear regarding the motion in the end, and a motion to approve the appeal is a motion to overturn Ms. Hamlin's decision. A motion to deny the appeal is to uphold that original decision, correct?
Yes, that is correct.
Okay.
Mr.
So
Chair,
I just want to interject so that there's no misunderstanding here. You all were sent a motion template, and the way it's drafted is that the motion to uphold would be to uphold the zoning administrator's determination. The effect of that would be a denial of the appeal. The motion to reverse would be a motion to reverse the zoning administrator's determination. And the effect of that would be to grant the appeal.
Okay, actually, that's clear.
Okay,
Yeah, thanks.
Mr. Chair,
Actually, all comments should be directed to Mark at this point.
got it. Okay. Mark, so just a quick clarification. So for, this is a slightly different process for zoning administrators determination. So for the request for variance, we have 7 criteria that we have to go through to determine if a variance can be granted. Do we have any guidelines about what we're looking for in terms of criteria for assessing the zoning administrator's determination? Thank you.
Good question.
Yes, there is actually some criteria. We can actually go through the staff report, but it's essentially, again, what Ms. Hamlin brought up about. It's really about how we apply the setback to what we define as a school. So that's really the guidelines, and also that what the 4 issues that the appellant is arguing. We responded with our 4 points. So those are the kind of those are the guidelines you want to consider to make sure when you're making your decision that it's falling within those guidelines.
So just to follow up on that question, so it's basically reviewing what was said in those responses and determining if we feel that they are correct.
Yes.
so
All right,
this
thank
is
you.
again, Piri Glinsky in the city attorney's office. So I think what you're getting at is kind of what's your standard, what do you have to find? So basically you will be reviewing the zoning administrator's determination of whether or not this facility and the use that is occurring there is a school, and whether in reaching that determination, she acted arbitrarily or capriciously, in other words, without any reason or without coming to that decision through a reasoned approach backed up by facts and the law. And you'll be determining whether or not the appellant has any vested rights in any improvements that have been done to date based on any validly issued permits. So does that help?
Yes, thank you.
Mark, Jesse Lugo. Mark, does the city of Tucson have a city ordinance that limits square footage for dispensaries?
What was that?
Yes, it does.
Okay, thank you.
Mark, could you repeat Jesse's question? I didn't really hear that.
His question was, is there an ordinance that limits the square footage for a dispensary?
Oh, okay.
I've got a question, Mark. I am a little bit unclear about educational use in terms of, like, is there a distinction between a facility having educational uses as part of like their certificate of occupancy and the like literal amount of time being spent in the building by students who fit that like category that they talked about of the K through 12 private or charter? It's, you know, it's like going through the protests and reading things like, oh, well, you know, these are like art classes for adults drinking wine, and sort of insinuating that that's not the same educational use that would prevent this expansion from being permitted, you know. And then relatedly, I am curious to know how much we're supposed to consider public input in making a determination.
I'm sorry, I'll go ahead and defer the first part to Ms. Hamblin. As far as the public comment, anything that is relevant to the determination or the appeal is what we can consider. Anything relevant.
So the first part of your question, Miranda, was really about if the code sets any parameters for time or amount of occupation potentially of a building in determining its uses. It does not. So we frequently may have multiple uses operating within the same facility, within the same building. So that's not uncommon. In this case, the code does not specifically outline the number of students, the time of the time that they spend in the facility for classes or any other such parameters. It strictly just defines what the space is being used for.
And it doesn't matter if the students are adults or children, that's an educational use.
To clarify, there are different categories of educational use. I don't have that section of the code right in front of me, but there is like educational uses for, you know, something like a dance studio. And then there's educational uses, which are formal education, K through 12 kind of education. Those are defined separately. And in the determination, the definition for essentially schools was used as part of that, not the definition for more informal educational uses.
The school definition.
Yeah. Yes.
Because I noticed there was so much back and forth and just really getting into the sort of granular level of definitions of schools and what this particular setup is at Santa Teresa Tile Works, and just really noticing like very big discrepancies between what your findings were and what the applicants or the representatives of the applicants had to say. And so it seemed to me at some point they had a really strict way that they were approaching that educational use, like a more traditional school. But it sounds to me like in this case, it's not hinging on Santa Teresa Tile Works being more like a traditional school. It's just education is part of like what it could be used as. Is that right?
So
I think we
to
want
clarify,
to some discussion to the actual meeting. We don't want to get into the beef of it while we're in study session, which is more for general questions about the code or procedure. So if you have questions, Ms. Hamblin, on particular points that were raised in the staff report or the zoning administrator determination, those should be made during the actual hearing portion of the meeting today. But asking questions about whether, if she can answer if it's in the code, then that's one issue. Asking for her to explain her interpretation is getting into what you will be deciding at the hearing. So we should wait till the hearing to discuss those points.
thank you,
Gotcha.
Carrie.
Okay. Will the proposed expansion take the facility over the 10,000 square foot limit? Anyone?
Ms. Kubish, can you repeat the question, please?
Yes. Would this proposed expansion take the facility, the downtown dispensary, over the 10,000 square foot limit?
We'd have to look into that. Ms. Kubish, we're looking into that.
Okay. Thank you.
Do we have any additional questions?
None from me.
At this time, I think I'm going to ask the chair if you would like to break into executive session.
Mark, I'm going to ask you to repeat that if you would not mind.
Would you like to go ahead and break into executive session?
If that's in order, I didn't know there was an executive matter to bring up, but if if we have concluded all our questions and all of your presentations, then let's consider this study session completed. And then if there is another matter of a executive level that you want to bring up, that's fine with me, and I'm sure with the board members.
You want to go into?
So unless there's a legal question that needs to be addressed by the board, I don't see the necessity of going into executive session at this time.
Well, I defer to you and Mark and Lisa. That's we're kind of ignorant of the subject matter, so we can't make an intelligent comment on that.
Well, we'll go ahead and break into executive session. So what I'm going to do is put the board members into a breakout room. Mr. Chair?
Is that Mr. Castro?
Yes.
Yes, I'm here.
Okay, let's go ahead and wrap up the study session. We have one more item to discuss.
Okay,
That's,
let's do it.
Number 3, it's the unopposed request for a continuance of case C10-21-09. That's the TEP to Keno to DMP 138 transmission line upgrade. So this is an appeal of the zoning administrator's determination pertaining to UDC section 554B. The appellant is here today to request an additional continuance. The city's position on the request is no objection. So we're asking that we go ahead and move this item to the beginning of the agenda. So we need to request to suspend the rules so that we can move this item to the front of the agenda, hear this first, and then continue on with the remaining cases.
Just a question for you. How do we continue an item that was not on the agenda originally, or was it? It's not on the agenda as a hearing for today.
That's correct. It was on the November agenda as another business item. And that's when they requested the continuance. So the continuance is expiring this month. So they need to request additional continuance. So a public hearing has not been held on this yet.
Okay, so the action would be to extend the continuance.
That's correct.
And all you're asking at this point in the study session is that the board members agree to move it to the front of the line once the public hearing is open?
Correct.
And what action is that? We're not even empowered to take action during a study session, are we?
Right, no, so that would happen once we're in the meeting and there's a vote to take an item out of order, Chair Marks, and if that's approved by a majority of the board, then you could go ahead and consider that item out of order and take care of it first thing.
Okay,
I think Mr. Castro is just making you aware that he's going to be asking you during the regular session to take that item out of order and continue it so we can move on.
Gotcha. Okay, I see no problem with that. Okay, Mark, I think that does it.
Okay, we'll go ahead and adjourn the study session and go right into the public hearing.
Should we start immediately, Mark? If we are starting immediately, then my first comment would be directed to Ms. Hamblin and ask for a roll call.
Can you hear me okay, Chairman?
Yeah, I hear you now. Yes.
Okay, great, thank you. I'll go ahead and proceed with the roll call. Michael Marks,
Here.
Bruce Dawson,
Here.
Kathy Kubish,
Here.
Jesse Lugo,
Here.
Lee Pagney,
Here.
Miranda Schubert.
Here.
Mr. Chair, we have a quorum.
Okay, very good. Well, I want to welcome everybody to the City of Tucson Board of Adjustment meeting. The date is May 25th, 2022. My name is Michael Marks. I'm the chairman. This meeting is being recorded, and by you joining the meeting, you are giving consent to the recording of that meeting. Once we begin where we complete these introductory comments, we will turn to staff for a introduction to each case. We have 3 cases on the agenda today. At the conclusion of staff's presentation, the applicant or the applicant's representative will have the opportunity to speak. And for the record, please tell the board your name and address and state your request. At the conclusion of the applicant's presentation, other persons wishing to speak in favor of the request may indicate so by using the raise hand feature located in the reactions tab at the bottom of your screen. Please be sure to state your name and address when recognized by the chair. When called by the chair of the board, those wishing to speak in opposition to the applicant's request may indicate so in the same manner using the raise hand feature. The chair may allow the applicant the opportunity for a brief rebuttal. The chair will then close the public hearing and open up a discussion by the board members. At the conclusion of the board's discussion, a motion will be made, and if seconded, will then be voted upon. All presentations today must be directed solely to the board and not to staff or members of the audience. All presentations to the board must also be only on those items brought before the board. Presentation on matters unrelated to the request will not be heard. The decision of the Board of Adjustment may be appealed to the Superior Court of Pima County by filing a complaint for special action with the Pima County Superior Clerk's Office within 30 days of the board's decision. For additional information on this filing process, please contact the Superior Court Clerk's Office or an attorney after today's public hearing. If you are going to give testimony today, please be brief and to the point. Repetition of testimony already given by other witnesses is not necessary, and the chair may invoke a time limit if deemed necessary, and we'll get into that as we get into the hearings coming up. Before you testify, please remember to state your name and address, and all testimony to the board must be given under oath. At this point, I'm going to ask city staff to raise their right hands. And all members of city staff who are planning on or who may give testimony, could you raise your right hands, and do you swear to tell the truth and nothing but the truth? I actually didn't hear anything.
Yes.
Okay, very good. So thank you. Just a reminder, please be sure to mute yourself and turn your camera off unless you were addressing the board. We have 3 items on the agenda where we discussed in study session the possible arrangement of those 3 items. So I'm going to turn to Mr. Castro and ask him for his comments on the agenda order.
Yes, Mr. Chair and members of the board. On the agenda, we have other business item A, which is an unopposed request for continuance of case C10-21-09. Staff is requesting that we take this out of order and put it to the front and hear the appellant's request for a continuance prior to opening the public hearing for the remaining 2 cases today.
Mr. Castro, the motion would be to extend the hearing date, but is there a specific date that it should be extended to?
Mr. Chair, it's a 6-month extension.
So we can just use that language.
Yes, Mr. Chair.
Okay, if that is all you planned on saying on that matter, I'll turn to the board members now and ask, is there a motion a board member would like to take or would like to offer to continue this matter for 6 months?
Mr. Chairman, Jesse Lugo.
Mr. Lugo.
I move that we suspend the rules to move the continuance of C-10-21-09 to 6 months continuance.
Very good. Thank you, Mr. Lugo. Is there a second to that motion?
I second that motion.
All those in favor say aye.
Mr. Chair,
Yes.
Mr. Chair, the proper procedure was to suspend the rules to take that item out of order first. And
Well, I think Mr. Lugo did say, include in his motion to suspend the rules. Is that not correct, Mr. Lugo? Mr. Lugo, do you hear me?
There you go. Yeah, what I stated was to suspend the rules to move the continuous on C-10-21-09 to a 6 month period.
I think that's the motion that would work. Is there a second to that?
I second that motion.
Okay, now, all those in favor say aye.
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 I,
Aye.
All those opposed say nay. Hearing none, the motion carries unanimously. So we will now move to what was the first item on the agenda, which is C-10-2202 White and Treadway Lot Line Adjustment. This is a continued matter. As I recall, we continued it after we had closed the public hearing. Failed to carry a motion that was then made and then directed the petitioner to talk with the affected parties about the one issue that became evident during the hearing, and that was the discrepancy between the actual lot line change and the one that was mentioned at the neighborhood meeting and may have also been mentioned in some of the written documentation. Having said that, I want to turn to Mr. Castro and ask, is there a new staff report that you want to report to the board at this point?
thank you, Mr. Chair and members of the board. I'll read into record the addition of the City Historic Preservation Officer's comment that was added to the staff report. So this is a continued case from April 27th, 2022. It is CKC 10-22-02, White and Treadway Lot Line Adjustment, Glenn White and Mona Treadway, 86 West Simpson Street, HO3. So the applicant's property is approximately 4,715 square foot lot, zone HO3, and office zoning classification, and is developed with the single family resident. The applicant is proposing to reposition the lot line between 86 and 92 West Simpson Street to provide parking for 92 West Simpson Street and create a reduced lot size and reduced building setback at the west lot line to the residents of 86 West Simpson Street. The applicant is requesting the following variances. 1, to allow the lot area for 86 West Simpson Street to be reduced from the required minimum of 5,000 square feet to approximately 3,379.5 square feet. And 2, allow the building perimeter yard setback for 86 West Simpson Street to be reduced from 10 feet to 4 feet as measured to the repositioned west lot line, all as shown on the submitted plans. In related plan reviews, the engineering section of Planning and Development Services has no objection or adverse comments. The City Historic Preservation Officer noted that lot line adjustments and lot splits are not typically reviewed by their division, but that the proposal is consistent with lot sizes and setbacks found throughout the Barrio Viejo neighborhood. Planning and Development Services staff recommends approval of the applicant's requested variances. It is the opinion of staff that the granting of the variances will not constitute a grant of special privileges inconsistent with the limitations upon other properties in the vicinity and zone in which such property is located, will not be detrimental to the public welfare or injurious to other property or improvements, and will not substantially diminish or impair property values within the neighborhood. To date, we have received a total of 2 written approvals and 3 written protests. And for the record, the board members have been provided copies of those forms. At this time, Mr. Chair, this concludes staff's presentation. We'd be happy to answer any questions.
So I have one thing to say, which I think is a comment, but maybe can morph into a question. And that is, despite the reference to the lot line change, the board is not asked to approve a lot line change today. The board is only asked to vary the minimum lot size and the setback of the lot with the address of 86 West Simpson. The lot line shift as proposed or planned by the applicant can't be accomplished to the extent that he and she wish to shift it without the variance. But we're not directly approving a lot line shift. Is that not correct?
Mr. Chair, so the matter before the board is really about the minimum lot size requirement and a building setback.
Mm-hmm. Okay. Okay. And just so we officially understand the status of the hearing at this moment, we have closed the public hearing already at the end of the last hearing date. Is that correct? And then if we want to hear anything further from the applicant and or any of the affected parties, we will have to first reopen that public hearing, which can only take place with a motion and a second that is then carried by the full board, correct?
That's correct, Mr. Chair.
Okay. Okay, that is all I had to ask and say. Are there any other questions or comments by other board members, or do you want to move right into taking action on the public hearing?
I prefer to move right in and take action.
Okay, is there a motion on the floor to open or reopen the public hearing?
Mr. Chairman, Jesse Lugo,
Yes, Mr. Lugo.
I move that we open the case. I move that we grant the following variances in case C10-22-02. 1, allow the lot area for 86 West Simpson Street to be reduced from the required minimum of 5,000 square feet to approximately 3,379.5 square feet. And 2, allow the building perimeter yard setback for 86 West Simpson Street to be reduced from 10 feet to 4 feet as measured to the repositioned west line, all shown on the submitted plans. Subject to the following conditions, there are none. The evidence presented to the board shows that there are special circumstances which were not self-imposed, which are applicable to the property and support the granting of the requested variances as set forth in staff report on pages 2, 3, and 4, findings 1 through 7, and specifically, the variances with the conditions imposed will not be materially detrimental to the public welfare or injurious to other property or improvements in the neighborhood, and it is the minimum necessary to provide relief.
Mr. Lugo, that is a very complete motion. And it may be that there is a second and that we would take action on that, but I thought we would provide the petitioner with the opportunity to report to us whatever progress was made with the neighbors or not. But since the motion was made, I want to provide the other parties with an opportunity to second that if any other party wishes to do that at this point in time. So is there a second?
Mr. Chair, I second that motion.
So at this point, we will vote on that. But before I call for a vote, there is the opportunity for a substitute motion or a friendly amendment. Is there any from any other board member? Okay, with there being a motion made and seconded on the table, I will call for a vote, the motion being to approve the two variances. All those in favor say aye.
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 All those opposed say nay.
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 Ms. Hamlin, can I have a roll call?
Give me just 1 second. I'm gonna go ahead with the roll call. Michael Marks,
Yay.
Bruce Dawson,
Yay.
Kathy Kubish,
Nay.
Jesse Lugo,
Yes.
Lee Pagney,
Nay.
Miranda Schubert.
Nay.
Could I have a repeat of Michael Marks and Bruce Dawson? My audio was cutting out a little bit. Michael, can you repeat?
Yes.
And Bruce?
Yes.
The motion fails.
The motion failed, and that gives us the opportunity, the option of somebody making the motion to reopen the hearing. And I would add the caveat that we limit the input from any and all parties to no more than 3 minutes, given the fact that we have heard so much on this case already. So is there such a motion to be made?
Mr. Chairman, I would move that we reopen case C-10-2202.
Okay, very good. Is there a second?
Mr. Chair, I second that to reopen the public hearing.
Okay, all those in favor say aye.
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 All those opposed say nay.
Nay.
So we have to go to a roll call again. If we could have that, Ms. Hamlin.
Michael Marks,
Aye.
Bruce Dawson.
Nay.
I'm sorry, was that a nay?
Yes, that was a nay. That was a no.
Okay, Kathy Kubish,
Yes, aye.
Jesse Lugo,
Aye.
Lee Pagney,
Aye.
Miranda Schubert.
Aye.
Motion carries.
The motion carries. Okay, so I want to impose that 3-minute limit. And I want to urge the petitioner and any other parties who speak to avoid any repetition from last month's presentations and avoid anything other than what relates directly to the case at hand. So let me ask, is the petitioner present?
I am.
Mr. White?
Yes.
yes, I need to swear you in again. Is your wife, Ms. Treadway, present? So if possibly both of you may speak, if I could have both of you raise your right hands. Do you swear to tell the truth, nothing but the truth?
Yes.
Okay, okay. So, Mr. White, since you're in the larger screen, why don't you tell us what's happened since the last hearing? Have you met with any of your neighbors, and have you discussed the lot line change and any other matter that came up that we might find pertinent? But if you could keep your comments to a minimum.
Sure. I did meet with everybody who showed up for I invited everybody who showed up for our first neighborhood Zoom meeting to come and physically see the space, see where the lot line confusion was and is. I think 5 folks showed up, 5 of the 7. I have my numbers right. We also looked at the plans. We looked at the plans for the proposed carport that kicked all of this off. That was that. And then since then, I've found that the lot line that I was confusing, that was on our legal description of the property, in checking with the title company, they made a mistake, filed an incorrect legal description. The board should have received an affidavit from them saying that they did make a mistake and they're correcting that. So those are things that have changed.
Okay, okay. Well, very good. Ms. Treadway, do you have anything to add to that? I see you shaking your head no. Thank you. We don't need to belabor this any more than we need to. So let me just ask, is there any other party, either in favor or in opposition, who either did not speak last month or has something that can be said very briefly that is new? Is there anybody in that category?
Use this one?
Use this one.
I am not sure I'm hearing anything or not. I'm gonna say I don't hear
My
anything.
hand up. I have my hand up.
Okay. Would you put your video on?
Sure.
Okay, if I'll swear you in, but I just want to repeat, we want to keep this as brief as we can. And if you can raise your right hand, and you swear to tell the truth, nothing but the truth.
I swear to tell the truth, nothing but the truth, yes.
Oh, okay, and if you could state your name and address.
Julian Goldfine, 440 South Convent Avenue.
Okay. Tell me what you have to add to your testimony from last.
Yes, well, I also discovered that there was a problem with the title. I've set it out in my objection at some length. And as things stand, there is a 15-foot tranche of land right down the middle between 86 and 92 to which the applicants do not currently have title. That being said, they can't continue to make a motion regarding that piece of land. There is another party who should be involved in that, and he's not here. And in those circumstances, I don't believe the board can possibly grant the application. There's a third party.
So this assertion of yours has that been presented to staff with any evidence?
Oh, absolutely. I wrote I think it was a 10-page supplemental objection on it.
Okay, and that's new since the last month.
Yes.
Okay.
And it was some days ago, and I did get a response that it had been received. So if you haven't seen it, it is crucial that you see that, because I lay out in detail, and it sounds like Mr. White has also come to the same conclusion, that there was that the conveyancing has left them with a flawed title. There is a 15-foot stripe of land right through the parking area that we're talking about that was not conveyed to them. It remains in their successor's name. So I don't see possibly how we can go forward, that being the case.
Okay, well, we'll discuss that and we'll see what we can do with that. And does that conclude your additional comments?
Well, I also supplied photographs of each and every curb cut within the notice area that showed clearly that that contributing properties that really that in the whole of that, in all of those curb cuts, which constitute about a third of the properties in the area, there's only 2 that had covered parking. And so it is not a privilege that is generally available to the neighbors of this property. And it is a requirement that the board find that because there are special circumstances applicable to the property, strict enforcement will deprive such property of privileges enjoyed by other properties of the same classification, the same zoning district. Well, you're looking not at 92, you're looking at 86. This application is in respect of the setbacks for 86. There's no privileges involved in this. The only thing that they're asked, if you like, they would be accepting detriments, not privileges. So 86, and this application is strictly in terms of 86. They haven't even proved the first point that that there are privileges that they feel they're entitled to that other properties have. So it's just, it's a non-starter. And certainly it's not something that's common in the neighborhood. In fact, it's rare, very rare.
Okay, and I think we heard that last month already. And just to speak directly to your reference to the covered parking, that is not a matter that is directly before us today. It is only the 2 issues, the reduction of lot size and the reduction of the setback. Thank you for the additional input, and I think we want to see if there's anybody else that has anything further to say as well. So thank you. Let me ask, is there anybody else that wishes to speak to this case?
Mr. Chair, is this appropriate for me to ask a question at this time?
Yeah, if you have a question of the petitioner, or did you have a question of the lady that just spoke?
I have a question of the petitioner.
Sure, you can do that right now. That's fine.
Okay, just in the staff report, we have the applicant's property is approximately 4,700 square feet, and the proposal is to reduce it to 3,379. Is that correct?
Yes.
Okay, so that is a reduction of 1,300 square feet. If you divide that by the north-south line of the property, which is 60 feet, I come up with a 23-foot difference between those 2 lines. And so in the proposal was stated that there's a 4-foot change in the lot line, or 48 inches. I'm sorry, no, it's 50 inches. So I'm seeing a mathematical difference of what is said in the application and what I'm reading in the staff report.
Right, and that's what I spoke to initially when I said that with the lot line confusion, the pin that I was going off of is the pin that I was always told was the property line that was placed there right before we purchased the property, and that's the one that was filed incorrectly with that the title company filed incorrectly, and it was supposedly where the previous owner was hoping to do a similar thing, is all I can guess. And again, going off of the legal description that we had, that's why I kept saying this property line is only 50 inches away from where we want to move it, not the actual 21.4 inches. And the statement that we don't own that piece of land in between is just patently incorrect. And again, there's an affidavit from the title company stating that. So.
So just to reiterate my question, so
Sure.
are we going back to the original 50 inches of change or 21
No.
feet of change?
Nope, it's 21 feet. What doesn't change in either one of those scenarios is where we're proposing moving the lot line to.
Understood. Just that clarification was what I needed. Thank you.
Sure.
Mr. Chairman,
Yeah, let me just complete the public hearing part so I can close the public hearing. And I did not hear whether any other party in the neighborhood wished to speak. Nobody responded. I'm assuming, and I still don't.
We have another raised hand, actually, Mr. Chair.
Is that Greg Kuykendall?
Yes,
Okay, you want to speak at this point?
yes. The only thing that I was going to add was paragraph 29 of Ms. Goldfein's objection, I think raises a very valid point from a procedural perspective. And that is that the UDC, that section of the UDC 3.10.3.k requires that all 7 findings be made in the conjunctive, not in the, I forgot what the opposite of conjunctive is, but the disjunctive, and that all 7 of them have to be found. And the conclusion of the staff report doesn't address all 7 of them. And consequently, I don't think that the staff report's conclusion is valid as a matter of law under, if you apply section 3.10.3.k, requiring that all 7 of those findings be made. And I'm a stickler for procedure, and that's why I think that section of Ms. Goldfein's objection really needs to be paid attention to by this board. That's all I had to say.
Okay, well, thank you. And just as a comment in response, staff's report is their advice to this board. This board will make a decision, and this board will make a determination regarding the findings.
Mr. Chairman,
Okay, I will close the hearing, having heard from all the parties wishing to speak. And I will turn to the board and ask at this point whether there is a board member that wishes to make a motion. Mr. Lugo.
Mr. Chair, I would like to ask a question of the petitioner.
Mr. Chairman, I was first.
Yeah, you
Go ahead.
were, and I apologize, Ms. Kubish. Maybe we should have paused a bit before, and maybe there still will be an opportunity. But Mr. Lugo, you were first, and so if you have a motion to make.
Well, before my motion, I had a question for Mr. White. Is that appropriate to ask now?
Yeah, let me allow that those questions of both you, given that you're not making a motion, and Ms. Kubish, and I will ask or make a comment at that point too. So, Mr. Lugo, why don't you proceed?
Yeah, the question for Mr. White is, he indicated they had 5 residents that had a meeting. What I'd like to know is whether or not those individuals then supported his updated variance, and if Ms. Goldfein and Mr. Kuykendall were present at that meeting.
They both were present at the meeting, yes.
And what was there a favorable results based on your updated information that you gave them?
They seemed to enjoy the wine that I gave them. But no, it was unclear. I mean, everybody left with smiles and saying, thanks for having us over and clarifying things. Yeah.
Let me ask Ms. Kubish to ask the question. I think, Ms. Kubish, you had a question for Mr. White. Is that correct?
Yes, that's correct.
That's correct. May I ask it now?
Yes, please do.
Mr. White, I've driven past your property so I could see for myself what was going on. And what I see is a driveway, also this described as an easement between the two houses, 86 West and 92 West. Now, what I can't get from your surveyor's map is whether or not your proposed lot line would encompass that entire driveway. In other words, would it extend pretty much to the door of 80, the side door of 86 West? Or would it divide somewhere in the middle?
I'm sorry, can you ask that one more time?
It would extend what we're
Okay,
proposing is it would extend to, there's a sidewalk and then there's a porch and then there's the door of 86 West Simpson. So there's a side gate, there's a sidewalk, there's a covered porch, and then the door and access to an outdoor shed on the side. But yes, it is covering most of that dirt driveway area.
Thank you.
For the record, that was Ms. Treadway that was speaking. I just want confirmation from either Ms. Treadway or Mr. White regarding the ownership of the entirety of what is known as parcels 1 and parcel 2 as depicted on the survey map that you've provided to staff and that we now have. As I see that map and as I see the 2 legal descriptions that are associated with that map, there is no exclusion acknowledged in any way by the map or by either of the 2 legal descriptions. So the conclusion is that your ownership extends without any over the entirety of those 2 parcels. Is that not correct?
That's correct.
Is there any basis for the assertion that you are aware of that there is an exclusion of ownership there?
Absolutely not.
Okay. Well, I think we've heard everything. Thank you very much.
Can I? And maybe I don't need to do this. One of the objections was raised that it's just not like lots of this size. The size that we're asking for or diminished lot size don't exist in this area or are not common, as well as the setbacks being lesser than 10 feet. And I don't know if the members of the board saw the information that I sent in and to Mr. Castro, showing all of the properties within 3 blocks of us that are less than 5,000 square feet. And the 5 or 6 within 1 block that are. So I'm proud of the presentation that got put together that we didn't get to show. And I just wanted to mention that.
Okay.
It's a common.
We understand. I think we have heard all that we need to hear. I think you've answered all the questions. We appreciate the input from the neighbors. I personally, as a member of the board, am satisfied that I have all the information I need to make a decision. So I, again, will turn to the board members and ask, is there a motion to be made to approve the request?
Mr. Chairman,
Mr. Lugo,
I move that we grant the following variance in case number C10-22-02. One, allow the lot area for 86 West Simpson Street to be reduced from the required minimum of 5,000 square feet to approximately 3,379.5 feet. And two, allow the building perimeter yard setback for 86 West Simpson Street to be reduced from 10 feet to 4 foot as measured to the repositioned west lot line, all shown in the submitted plans. Subject to the following conditions, there are none. The evidence presented to the board shows that there are special circumstances which were not self-imposed and which are applicable to the property and support the granting of requested variances as set forth in the staff report on pages 2, 3, and 4, findings 1 through 7, and specifically, the variances with the conditions imposed will not materially detrimental to the public welfare or injurious to other property or improvements in the neighborhood and is the minimum necessary to provide relief.
thank you, Mr. Lugo. Is there a second to that motion?
Yes, I second that motion.
Mr. Dawson? Okay, thank you. We have a motion on the table to approve with all the conditions as stated verbally. Can I, Ms. Hamlin, can I have a roll call?
Sorry, Michael Marks,
Aye.
Bruce Dawson,
Aye, yes.
Kathy Kubish,
Nay.
Jesse Lugo,
Aye.
Lee Pagney,
Nay.
Miranda Schubert,
Nay.
motion fails.
Okay, so we are in a,
Okay, so this is Perry Glinsky in the City Attorney's Office. You being a presiding member of the board, Mr. Marks, and this being a board that does not vote by ballot, you can abstain from the vote in order to break a tie, and that would be my recommendation at this point, there having been 3 tie votes.
now, Ms. Hamlin, what was that vote? Was it 3-3?
Yes, that's correct.
Okay, and Ms. Glinski, only somebody who voted in favor of that motion can withdraw that vote. And then,
Mr. Chair Marks, I recommend that you be the abstaining officer as you are the presiding officer of the board and do not have to participate in the vote.
and that way there would, the vote would fail 2-3, or it would fail with 3 votes opposed and only 2 votes in favor. Is that
Chair
not-
Marks, there needs to be a resolution. So you being the presiding officer have the ability to cast the deciding vote. And in this case, it would require that you abstain in order to
Well, I hear you. That makes a lot of sense. I don't necessarily agree with the end result, but otherwise we're in a sticky wicket. We just can't move. So if I were to do that, and that could be done by my declaration at this point, if I hear you, we don't need any other motion. We don't need to redo this motion. I could just declare now that I withdraw my vote, and the resultant votes would result in a denial of the request.
Mr. Chairman, Jesse Lugo,
Yes, Mr. Lugo.
you have a right, just like the rest of the commissioners, to make a vote. So I don't agree with the legal statement that was given to you. So with that, I'd say, hold your ground and you have a right to vote on it.
Well, I really agree in substance, but procedurally, I don't know that there's any other place for us to go. And continuing it one more time, one more month, unless there is some testimony that comes in that changes everything, I don't think things would be any different. So while I'd like to hold my ground, I will take the recommended action and I will withdraw my vote. And therefore, the motion to approve will have failed by a vote of 2 in favor and 3 opposed. Is that not correct, Ms. Glinski?
That's correct, Chair Marks. If you are abstaining from the vote, then the vote would, we would vote again and the vote would be 2 to 3.
Okay. Well, we don't need to vote again. It now already is 2 to 3, correct?
Mr. Castro, is there a provision in the board rules for withdrawing votes? Or should there be another motion?
Just give us one moment to look into that.
So if there is no specific provision within the board rules, Mr. Marks, then I would suggest that you abstain from the vote and that another vote and a motion be made and that vote be tallied.
Okay, so we do need to redo the vote. So, Mr. Lugo, do you want to repeat the vote or the motion you just made?
Yes. I move that we grant the following variance in case number C10-22-02. 1, allow the area for 86 West Simpson Street to be reduced from the required minimum of 5,000 square feet to approximately 3,379.5 feet, and 2, allow the building perimeter yard setback for 86 West Simpson Street to be reduced from 10 feet to 4 feet as measured to the repositioned west line, all as shown on the submitted plans. Subject to the following conditions, there are none. The evidence presented to the board shows that there were special circumstances which were not self-imposed, which are applicable to the property and support the granting the requested variances as set forth in staff report on pages 2, 3, and 4, findings 1 through 7, and specifically the variances with the conditions imposed will not be materially detrimental to the public welfare or injurious to other property or improvements in the neighborhood and is the minimum necessary to provide relief.
Thank you, Mr. Lugo. Mr. Dawson, do you want to offer a second one more time?
I will, and I do. I second the motion.
Okay, Ms. Hamlin, I'm going to ask for a roll call. I would ask that you pass over my vote until the end. So if you could proceed, but with me at the last.
Yes, Mr. Chair. Bruce Dawson,
Aye.
Kathy Kubish,
Nay.
Jesse Lugo, Jesse Lugo, it appears he's dropped out of the meeting. We'll come back to him. Lee Pagney,
Nay.
Miranda Schubert,
Nay.
Mr. Chair, I do not see Jesse Lugo in the meeting. Would you like to proceed with your vote?
Yeah, I'll abstain.
Okay,
So the vote is,
Do we still have quorum?
we still have quorum, yes.
Ms. Hamlin, what's the results of that vote?
We have 1 in favor and 3 nays for a total of 4 votes.
Okay, well, that achieves the quorum, but so the motion fails and the matter is denied.
That's correct.
That's correct. Okay. Well, Mr. White, Ms. Treadway, that is the end of that hearing. You may want to talk to staff some other day about whether you have any other options, but at this point, we have nothing further to do with your case. And good luck to you, however you are able to handle things. We have one more case on the agenda and we'll move to that. And Mr. Castro, could you give us a staff report for that last item?
Mr. Castro, this is Perry Glinsky in the City Attorney's Office. Would you like to try to locate Mr. Lugo?
I'm here. For some reason, I was dropped off the site, so I'm back.
Oh, good. Did Ms. Hamlin, did you got Mr. Lugo's vote?
I did not get his vote because he was out of the meeting when we were voting. Would you like me to call for his vote now?
I think just for the record, it would make sense.
Jesse Lugo,
Voting on?
the motion to approve the variance as set forth in the staff report.
Yes.
Thank you.
Okay.
We have
so-
1 abstention, 2 approvals, and 3 nays.
Okay. Okay, thank you. Is Mr. Castro here and ready to do the staff report for the last case?
Yes, Mr. Chair. Mr. Chair and members of the board, our next case is C10-22-05 Downtown Dispensary, 221 East 6th Street LLC. Address is 221 East 6th Street, zoning is C3. The appellant, C.R. Callahan, May Potenza Barangelewski, on behalf of Forever 46 LLC, is appealing the zoning administrator's determination T22SA00041 issued March 18th, 2022, relating to the city's application of setbacks to marijuana dispensary required by the Unified Development Code in section 499E1J, which states that the expansion of an existing marijuana dispensary shall be set back a minimum of 500 feet from a K-12 public, private, or charter school. The zoning administrator determined that for the purposes of applying the required zoning setbacks of a marijuana dispensary, as indicated in UDC sections 499E1 H and J, that the use of the property address 440 North 6th Avenue does meet the definition of a K-12 public, private, or charter school as established through a certificate of occupancy and as provided in the UDC, Arizona revised statutes, and Arizona administrative code. The appellant contends that the zoning administrator mischaracterizes the UDC sections 499E1 H and J as opposing a setback requirement from any property whereon a school may conduct educational land use activities. The appellant is requesting reversal of the March 18th, 2022 zoning administrator's determination. The appellant identifies the following as issues on the appeal. Although Planning and Development Services Department acknowledges Santa Teresa Tile Works is not a school, Planning and Development Services mischaracterizes UDC sections 499E1H and 499E1J as opposing a setback requirement from any property whereon a school may conduct educational land use activities. Point 2, Santa Teresa Tile Works facility is not a school within the meaning of ARS section 15-10121. Point 3, Planning and Development Services zoning determination is arbitrary, capricious, and abuse of discretion. And point 4, Planning and Development Services is stopped from denying Forever 46 its marijuana use authorization. The zoning administrator's arguments to uphold the determination. In response to point 1, Imago Dei Middle School located at 55 North 6th Avenue is a licensed private school providing education for grades 5 through 8. Santa Teresa Tile Works is a nonprofit subsidiary of Imago Dei Middle School. Santa Teresa Tile Works holds a C of O that was issued in 1998 for a use identified as art studio. The zoning administrator's determination acknowledges that Santa Teresa Tile Works activities include selling ceramic tiles on site and online, providing workshops and creating art pieces for the general public to view. In addition to these activities, and as an additional land use, art class is also taught at Santa Teresa Tile Works by Imago Dei Middle School staff and Santa Teresa Tile Works employees several days a week on a weekly basis. Imago Dei Middle School considers Santa Teresa Tile Works as its art campus and is mentioned as part of its curriculum. In response to point 2, private school as defined in ARS 15-802 G3 as a non-public institution other than a child's home where academic instruction is provided for at least the same number of days and hours each year as a public school. The definition as provided in the ARS does not preclude a private school from having multiple campuses or locations. The continuous scheduled use of Santa Teresa Tile Works for art classes establishes this location as a private school for the purposes of applying UDC section 499E1 H and J. In response to point 3, the appellant contends that this zoning administrator's determinations art campus theory is arbitrary, capricious, and an abuse of discretion. The zoning administrator's determination is based on facts and references to the UDC, Arizona Revised Statutes, and Arizona Administrative Code. In order to determine whether or not the 500-foot setback was applicable to Forever 46 marijuana dispensary expansion, the zoning administrator referenced the applicable sections of the Arizona Revised Statutes and the Arizona Administrative Code related to the definition of a K-12 public, private, or charter school. In response to point 4, the appellant asserts that they have a vested right in the expansion of the property because the city subsequently permitted Forever 46 expansion over the course of months beginning in July 2021. However, the appellant isn't correct both the facts and the law. The vested rights doctrine has been stated by Arizona courts as follows. Where a special use or building permit has been legitimately issued and the permittee has substantially relied thereupon and incurred considerable expenses, the right to continue construction under such permit becomes a vested right. On July 9th, 2001, the appellant applied for a building permit, activity number T21 CM05662, to make certain building improvements, including an expansion of the dispensary within the existing building envelope. On October 12, 2021, the required marijuana use authorization application was submitted and denied on December 6, 2021. No permit has been issued for permit activity number T21 CM05662. Therefore, the appellant has no vested rights to expand the building under law. Staff recommends upholding the zoning administrator's determination that for the purposes of applying the code required setbacks of a marijuana dispensary as indicated in UDC section 499E1 H and J, Santa Teresa Tile Works does meet the definition of a private school, and that the expansion of the marijuana dispensary does not comply with the provisions of UDC Section 499E1H and J. To date, we have received a total of 257 written comments in support of the appeal and one written comment objecting to the appeal. And as previously mentioned, those were counts as of 4 p.m. yesterday. And since then, to the beginning of this public hearing, we've received approximately 160 more in support of the appeal, bringing the total to about 417. And these are mostly located outside of the notification area. So again, just to, if you see the map that was provided for the study session, you'll see that there was only one or two that indicated comments that were received that were actually located inside the notice area. The rest are off the map. Mr. Chair, members of the board, this concludes staff's presentation. I'd be happy to answer any questions.
Yeah, Mr. Castro, this is Mike Marks. The question of support is kind of different than what we might typically deal with a variance, where there might be neighbors who are showing support for a specific modification to the code. This may be customers that just support the operation, but customers that live elsewhere in the community. So I don't know that that level of support is necessarily similar to what we typically receive on a variance request. Just a comment, and I don't know if you have any response to that. Feel free to comment.
So, Mr. Chair, just to clarify, this is a public hearing, and part of the process is to legally advertise the public hearing, which was done, and also send notice of the public hearing to those affected, to those within the notice area. But anybody in the public has the right to submit a comment regarding a request.
Understood. So let me ask you one question. I know we want to get into this hearing as quickly as we can. The facility in question that is being used for the art classes, I take it by comments you made and that are maybe were made by the appellant in his or her documentation, is not limited to the art class. The structure is used by other parties as well. Is that correct?
Mr. Chair, are you asking if there are other tenants in that building?
Well, not exactly. That might be interesting as well, but are there other people using the art studio that area that is used by the school?
Mr. Chair, I'm going to provide clarification on that question. I believe what you're asking is if there are other users of the building other than the students that may use Santa Teresa Tile Works, and that is correct. There are other users of the building. It is not solely an educational facility. We would consider it a multiple use facility, meaning it can serve educational uses as well as commercial or retail uses.
Okay. All right. Well, let me ask the board members, are there any questions any of you have of staff at this point?
Yeah, Mr. Chair, Bruce Dawson, I just a comment that I have personally used Santa Teresa Tile Works to do a project with my daughter a number of years back. So it wasn't being used as a school then. So that's all I have on that.
Okay. Okay, well, I'd like to move into the hearing and ask the petitioner, is he or she present?
Yes, we are present, and I would ask for permission to share a screen for my associate Kathleen Schaefer, as we have a visual presentation to go along with my remarks.
Sure, yeah, you could make your presentation jointly. We do want to limit the time to the extent that we can. Why don't you commence, and please remember we're trying to move through the hearing as expeditiously as we can without sacrificing any of the substantive material.
Thank you, Mr. Chair and members of the board. My name is Jesse Callahan, and my associate Kathleen Schaefer of May Potenza, Barron and Gillespie are appearing today on behalf of Forever 46 LLC, doing business as the Downtown Dispensary. Our address is set forth in our written appeal, 1850 North Central Avenue. I'm before you today because zoning administrator Eliza Hamblin denied the Downtown Dispensary zoning compliance for its permitted and constructed expansion of its existing marijuana use on the property at issue. Now, why did Ms. Hamblin make such a decision? According to her, the decision rests entirely on the premise that Santa Teresa Tile Works should be treated as a, quote, K through 12 public, private, or charter school. Now, keep in mind, the Downtown Dispensary and Tile Works operated across the street from each other for the last 9 years. So how did Ms. Hamblin suddenly become the first person at the city of Tucson to start thinking of Tile Works Art Studio as a school? Her conclusion certainly seems strange and unsupportable to us, so we submitted a federal Freedom of Information Act request. And in response, the documents that we obtained, they were disturbing. As it turns out, the Downtown Dispensary's competitor, Prime Leaf Dispensary, through its CEO, Michael Crawford, repeatedly contacted Ms. Hamblin, directing her to take this position. She did not reach this conclusion of her own research and accord. She was told to take this position by Mr. Crawford. So now we know the motive for the determination at issue. The question is, what mental gymnastics did Ms. Hamblin go through to reach the stretched conclusion that this is a school? The zoning determination expressly relies on one legal argument to support this position. Ms. Hamblin stated, and I quote, "The common use of art studio designated on this certificate of occupancy does not align with the defined use in the UDC." Now, when the staff report was just read, the language "does not align with the defined use in the UDC" was omitted. Ms. Hamblin went on to write, "In cases where a term is undefined," and this is very important, "where a term in the certificate of occupancy is undefined, the UDC provides flexibility to clarify the use as noted on the certificate of occupancy." That's where Ms. Hamblin derives the supposed flexibility she purports to be exercising. But as a matter of law, that's wrong. This presentation will address that the entire foundation of the argument crumbles apart because art studio does clearly align with the defined use in the UDC, meaning Ms. Hamblin had no authority to clarify the use of a defined term, no flexibility at all. That error alone renders the entire zoning determination void. Now, to make a clear record, of course, our presentation will address the other contentions contained in the zoning determination, but that single indisputable legal premise that art studio is a defined use in the UDC, that's dispositive. A commercial art studio, ladies and gentlemen, it is not a school, and a school is not a commercial art studio. These are separately defined uses in the UDC. Now, before we get into the heart of the appeal, it's important to look at the location and the other businesses operating in the immediate vicinity. This is all about a half mile from where the board usually meets in person, so I'm sure it is familiar to you all. In fact, you may have been to one or more of these businesses. The downtown dispensary has been approved by the city for marijuana use and has operated at 6th Street and 6th Avenue since 2013. Across the street from the downtown dispensary is the Royal Room, a restaurant that opened in 2017 and obtained a liquor license for a full bar in 2018. And Santa Teresa Tile Works, the tile studio, that's operated out of the same location since 1998. Now, as you can see, the Royal Room operates its bar in the very same building as Tile Works. This is the front of the so-called school. Now, where are the signs? You may be asking yourself, where are the signs that say this is a drug-free school zone? Where are the signs that say no weapons allowed? This quote unquote school, it's right next to a Miller High Life sign in a building with a full bar. It does not pass the eyeball test. News articles show that the Royal Room obtained its liquor license in 2018, which it could not have done if Tile Works was a school. ARS, Arizona Revised Statute, Section 4207 provides that no liquor license will be issued for a premises that is within 300 feet of a public or private school building with kindergarten programs or any of grades 1 through 12. The bar is in the same building as the so-called school. Now, 3 years after that liquor license was issued, the downtown dispensary pulled the necessary building permits to expand its facility. This expansion will create additional jobs in the Tucson community. It will increase tax revenue to the city, which will inure to the benefit of the entire downtown community. The downtown dispensary has been a boon to Tucson for years and continues to do great things in Tucson in the operation of its business. The expansion not only benefits my client, it stands to benefit so many Tucsonans. The downtown dispensary built its expansion pursuant to the properly issued permits, only to be told in December of 2021 that it cannot use the facilities on the basis that the Planning and Development Services Department now somehow finds, for the first time in 20 years, that Tile Works should be treated as a private middle school. So how is a self-described tile studio, showroom, arts and crafts store that's been around for over 20 years, how and when did that art studio transmogrify into being treated as a K through 12 public, private, or charter school? It wasn't in 2013 when the downtown dispensary was issued a marijuana use certificate of occupancy. It certainly wasn't in 2017 when the downtown dispensary was issued a certificate of occupancy for marijuana use for expanded facilities. Again, it wasn't in 2018 when the Royal Room obtained a liquor license in the same building as the Tile Works studio. It was just last year as the downtown dispensary was finished building its expansion. That's when it happened, suddenly, in December of 2021. Now let's look at the correspondence we obtained in response to our Freedom of Information Act request to see just how that happened. Through these public records obtained just before the appeal deadline, the downtown dispensary discovered that its competitor instigated this entire charade to delay my client's operations and harm its business. Michael Crawford is the CEO of Prime Leaf Dispensary, and he's even taken to the streets outside of my client to try to solicit business away from them. Mr. Crawford did not hide his agenda when he invoked, quote, karma, when he told Ms. Hamlin to start calling Tile Works a school. I quote, karma is alive and well, end quote. Now, this should have immediately raised flags for anybody. Why did Mr. Crawford say this to her? Did she know what Mr. Crawford meant by karma? Did she know of Mr. Crawford's past history with the downtown dispensary? Certainly one would think that Ms. Hamlin would continue to apply the department's past practice of relying on the certificate of occupancy to determine the use of a building. As noted in our appeal in prior cases, the department viewed the certificate of occupancy use as dispositive of the actual use. And certainly, Ms. Hamlin should reject all indications that Tile Works actually wasn't a school. She wasn't going to just try to exact the karma that Mr. Crawford desired. And as the appeal shows, Mr. Crawford didn't relent. He followed up on his plan more than once, letting Ms. Hamlin know in July that he had seen the downtown dispensary had in fact pulled the permits for its expansion. None of this information that Mr. Crawford was conveying was shared with my client. Again, we just recently obtained it. On October 21st, 2021, Mr. Crawford again called on Ms. Hamlin to deny the downtown dispensary its application for zoning compliance to use its properly permitted expansion. And he repeated, quote, again, karma is alive and well. And again, Ms. Hamlin did not question why Mr. Crawford felt comfortable saying all of this to her and did not convey any of this information to my client. The records show that the only information Ms. Hamlin had at this point of the denial were representations by Mr. Crawford, whose improper motives for unfair competition were obvious. Representations that one, Tile Works is, quote, Imago Dei Middle School's North Campus. That turned out to be false. All one had to do was look at the Imago Dei website to see it has no North Campus at all. The second misrepresentation, that the Tile Works lease supposedly confirmed that Imago Dei Middle School teaches classes at Tile Works. That was also false. All Ms. Hamlin had to do was look at the lease that Mr. Crawford attached. And Ms. Hamlin would have seen on page 2 that the permitted use of the facility was, quote, operation of arts business and related services and for no other purpose. It doesn't say school, ladies and gentlemen. Ms. Hamlin had this lease. I guess she just must not have looked at it. Now, the record is clear that Ms. Hamlin did not perform independent or impartial research. She merely regurgitated Mr. Crawford's misrepresentations when she denied my client's zoning compliance request. Mr. Crawford wrote that Tile Works was Imago Dei's campus, teaching its classes at Tile Works. Ms. Hamlin then wrote the unsupported conclusion that all art classes are held at the commercial art studio. That was false too. The denial was initially based on a single representation that the, quote, school uses this location as their art campus. This is what Ms. Hamlin wrote, and all art classes are held there. But this information was plainly false. Now, although Mr. Crawford's involvement and improper influence in this matter was addressed at length in the appeal paperwork, the department never addressed its communications with Mr. Crawford or denied any improper influence or denied that it blindly relied on Mr. Crawford's conclusory representations. I'm sure the board is aware that silence is generally construed as an admission. Now, members of the board, you should ask yourselves whether Tile Works looks like a middle school. And during the study session, the question was asked, when did Tile Works become a school? And the answer is, it never did. Not in October 2013. That's not a middle schooler sipping sangria. Neither are these ladies. Now, nice adults, of course, but they're enjoying libations together at the art studio. It wasn't a school in March of 2015. Not in November 2015, again, some adults enjoying libations. It wasn't in October of 16. These don't look like middle schoolers, nor in September of 2017, nor in March of 2018, or May of 2018, or June of 2018. Now, I like the shirt, bear down. I'm a U of A undergrad and law school graduate. But when Tile Works in June of 18, it stated it was open to the public on a Thursday from 10 a.m. to 5 p.m. Now, we all know school security protocol does not allow members of the public to enter their premises. Now, Tile Works also was not a school in August of 2018, or September of 18, or April of 19. Not in March of 2021, where Tile Works again listed public workshops. Not in April of 2021. Now, some of those pictures showed exposed insulation. I certainly wouldn't want my teenage child who's in middle school to go to a building with exposed wiring and exposed insulation as a quote unquote school. Now, Ms. Hamblin acknowledged in the zoning determination that any flexibility to clarify a use is only in cases where a term does not align with the defined use. And this is so important. And this is provided in UDC 11.2.5. The defined terms include definitions of land use groups, classes, and types of Article 11, Section 3. Ms. Hamblin erred legally. There's no deference on that. These are issues of law. Ms. Hamblin erred when she contended that the common use of, quote, art studio does not align with the defined use in the UDC. In truth, quote unquote, art studio is plainly within the technical service land use class in the commercial services use group, where, quote, commercial art studios is cited as an example of a typical use within the technical service land use class. The zoning administrator's determination relied on UDC 11.3.1b, which permits the administrator to make an administrative decision on the legal use where a specific use does not conform to the wording of any land use description. That is not the case here. Quote, art studio so clearly conforms to the technical service land use class. And so the UDC does not authorize Ms. Hamblin to determine that Tileworks aligns with the elementary and secondary schools land use type, which is what she expressly states she did. Ladies and gentlemen, art studio is used as a typical example of the technical land use class. Nothing else needs to be said. For this reason alone, Ms. Hamblin's zoning determination contains plain legal error and must be reversed. Ms. Hamblin is entitled to no deference on this issue. This is a purely legal issue of interpreting the code. Now, the department should acknowledge this error, this apparent oversight, and recommend reversal. Because of Mr. Crawford's involvement, we don't think the department will do the right thing. So we'll proceed with explaining for the record the other reasons why Ms. Hamblin's clarification using flexibility under UDC 11.3.1b is also legally incorrect and factually unsupportable. Now, in addition to lacking the authority to clarify the use, the purported clarification was legally and factually unsupported. We've listed 8 reasons on this slide. I'm not going to read each and every one of them, but I want the board to look at number 2, ARS section 15.501.21, as adopted by the administrative code, requires that the facility's primary function, and this is critical. There was a lot of discussion earlier that, well, it's a mixed use and it's blended. And there was a direct question that was made to Ms. Hamblin about whether or not it's just a school or whether there's other activities in that building. That's a very on-point question. And the answer plainly should have been yes, but it was evasive. The answer is not just whether other activities are there or not. The analysis is whether the primary function within that building is educating children. Of course, the zoning administrator did not determine the primary function in that building is educating children, nor is it the primary function. It's not even close to the primary function. The evidence shows, I want the board to look at item 3, and even the zoning administrator determination acknowledges that educating children is not Tileworks' primary function. So even if the administrator had flexibility to now clarify the use, if the primary function isn't educating children, then there is no flexibility. That determination of being a school cannot be made. And let's look at section 8 here. I'm going to skip over for the interest of time, 3 through 7, 4 through 7. They're important, they're in the record, but number 8 is really important here. Tileworks has not complied with ARS section 13.34.11 D and E, and that is required of a true school. I'm going to get to what those statutes mean and say in a second, but they are critical to the analysis here. Now, UDC 499E1J is unambiguous. Tileworks is not a private school. And that's clear by the fact that the zoning determination had to butcher the language of the UDC to try to fit a square peg into a round hole. The department could not represent in its zoning determination or in its staff report, and no one at the department can testify today that Tileworks is actually a middle school, yet the UDC refers to setback requirements from an actual school. If Ms. Hamblin cannot find that Tileworks is a school, Ms. Hamblin cannot legally deny the downtown dispensary its zoning compliance request. The plain language governs. Ms. Hamblin's attempt to change the plain language from an actual K through 12 school to anywhere that a K through 12 school might bus its children to for enrichment activities and field trips, that is not permitted legal analysis. And as set forth in the Maricopa County v. Rana case, 248 Aras 419, the court will look at this unambiguous text and strictly construe it in favor of the property owner, the downtown dispensary. Now, not only is Ms. Hamlin blatantly wrong about the certificate of occupancy, the UDC, Arizona statutes, and the code, but she cannot even bring herself to say Tile Works is a school. And that is what UDC 4.9.9.E1J requires to impose a setback. Ms. Hamlin cannot change that section of the UDC to impose a distance setback from any location that Imago Dei Middle School, in her words, quote, uses for some unconfirmed amount of time of Imago Dei's 50-hour school week. Now, Tile Works is not Imago Dei's art campus. Not only is the determination wrong by reinterpreting UDC 499E1J, but it's also premised on a false statement that Tile Works is Imago Dei Middle School's, quote, arts campus. Now, this is what Mr. Crawford had told her when he called Tile Works the Imago Dei Middle School North Campus. But on March 16th, 2022, Mr. Taylor confirmed that the arts campus representation was false. Mr. Taylor is the head of school at Imago Dei, which, by the way, is far away from the downtown dispensary, the actual school itself. We're talking about the Tile Works studio across the street. Ms. Hamlin knew at the time she made the zoning determination that Imago Dei Middle School actually uses its own facilities for its general arts curriculum because Mr. Taylor, the head of school there, had told her so. I find it fascinating, absolutely fascinating, that Ms. Hamlin based the determination off a fact that the head of school of Imago Dei had told her was not true. Now, the appeal we submitted included photos from Imago Dei Middle School's Facebook page of the children at Imago Dei, this is not Tile Works, engaging in plenty of other art classes, including quilting, collage making, and the like. These pictures look nothing like the pictures of Tile Works, which is a commercial business. The documentation is overwhelming. These students have a general art curriculum, and it is taught at 55 North 6th Avenue, the only designated campus of Imago Dei Middle School, well beyond 500 feet away from the downtown dispensary. Now, every convoluted argument that's manufactured in the zoning determination has been false and unresearched. It first said all art classes were held at Tile Works. That was a false statement that has yet to be acknowledged. That's not true. Then Ms. Hamlin said and continues to say Tile Works is Imago Dei's art campus, quote unquote art campus. But Mr. Taylor's statement prior to Ms. Hamlin's public zoning determination is the best evidence of the truth, which is that the general arts curriculum is taught at Imago Dei by Imago Dei staff. Ms. Hamlin says classes are held several days a week, but the public records request establishes that Ms. Hamlin did not review the Tile Works curriculum to verify the accuracy of what Mr. Crawford had told her. Now, the staff report says art is considered primary education, so any weekly workshops would count as the required education that makes the school. Once again, the department said a lot in this case without identified sources, but ARS section 15802A sets forth what subjects must be included in any required education, public, private, or otherwise, and art is not required, as the UDC plainly articulates. When Imago Dei middle schools do intend enrichment activities off campus, Tile Works is just one of many field trip locations. It is axiomatic that the law cannot be selectively applied. Absent a reversal of this zoning determination, development in downtown Tucson will come to a grinding halt because we will need to figure out all other locations that might be treated as schools, even though there is no certificate of occupancy or public record of it actually being a school. And that is an absurd result, which is why the certificate of occupancy governs whether a building is a school. It's not up to a zoning administrator illegitimately lobbied by a competitor to decide in the moment that the building will now be treated as a school solely to harm a competitor. The department is not attempting to hinder development all of downtown Tucson. So why is the department and Ms. Hamblin intent on hindering the downtown dispensary, if not for one reason, Mr. Crawford's demands? Now, Ms. Hamblin erroneously represented that a certificate of occupancy is not dispositive of the land uses legally occurring on a site. Ms. Hamblin cites no authority for that proposition, and in fact, it is in direct conflict with her earlier acknowledgement that UDC section 141B expressly prohibits the use of land that has not been certified through the certificate of occupancy process. But even under this erroneous and unsupported reasoning, the certificate of occupancy, which Ms. Hamblin at least acknowledges is generally indicative of the legal use occurring on a site, indicates that Tile Works is not a K through 12 public, private, or charter school. Now, this part is so incredibly important for the board to hear. This is what I referred to earlier. There are laws in place to ensure the protection of children at schools. That should be the board's priority, to protect the children. To become a school, these safety measures and these statutes have to be taken seriously and have to be completed. In this record, there is no evidence that Tile Works or Imago Dei submitted the critical information to the county attorney to comply with the laws to identify the boundary of the school. This is a statutory requirement that the county attorney and the county recorder be notified. It's not Mr. Crawford's game to play with the safety of children. One of the reasons that this is important to clearly define through public records like certificates of occupancy, where a school begins and ends, is to ensure the safety of school children, to ensure that people like sex offenders do not live or reside near a school. If where a school begins and ends depends on a zoning administrator's whim, none of these laws can be effectively enforced. Arizona law also requires permanently affixed drug-free school zone signs at any school or accompanying grounds. Not only is Tile Works failing to affix these, quote, drug-free school zone signs that are required to be a private school, they are actively consuming alcohol inside the studio, across the hall from a bar, and across the street from a dispensary and a brewery. The fact that Tile Works did not follow these procedures is just further evidence that this is a charade driven by my client's competitor. Without a specific boundary and drug-free school zone signs, no reasonable person could conclude this is a school. The city cannot just say it's a school to serve Mr. Crawford's purpose.
Can I interrupt for just a moment and let you know that you have been speaking for about 40 minutes. And we've been very tolerant of the amount of time you've used, but we'd like to see you start to wrap it up and wondered if you could do that within the following 10 minutes.
Absolutely. I should be done within the next 10 minutes at least, if not sooner. Thank you. I appreciate it. As for Ms. Hamblin's assertions that Arizona statutes and the Arizona Administrative Code require her to deny the downtown dispensary its zoning compliance, Ms. Hamblin is once again wrong. Not only does the Administrative Code not impose setbacks where a school was, quote, a quote, school was established after the dispensary certificate was issued, but neither the statutes nor the code, which applies ARS section 15101 properly applied, could result in a finding that Tile Works is a private school. Public schools and charter schools are easy to identify because the Arizona Department of Education maintains a list. When it comes to identifying whether a facility is a private school, the Arizona Court of Appeals in this division, Division 2, has articulated that a zoning official must consider whether the, quote, primary function of the facility is to educate children. This is the Vision Quest case. The downtown dispensary does not need to establish that school children never attend workshops or classes at Tile Works. Imago Dei Middle School's use of Tile Works even twice or 3 times a week would not come close to demonstrating that Tile Works' primary function is educating children. The certificate of occupancy governs. But if Tile Works sought to change its use, as the UDC would require, the zoning administrator would determine whether Tile Works' primary function is to educate children in the required subjects. Now, as we set forth previously in the appeal, Tire Works is open to the public, holding workshops, hosting group classes, selling its goods online, and engaging in commissioned works, all to generate revenue. The zoning determination already acknowledges on 3 separate occasions that Tile Works is actually not a private school. But had the zoning determination identified Tile Works facility as a private school, that would be clear error based on the primary function test. Now, where the zoning determination was so clearly issued in error, it is incumbent upon the department to acknowledge and correct this error. As a department of the city of Tucson, the Planning and Development Services Department is expected to seek the correct and the fair result. The department should not advocate a particular position that has no basis in the UDC and in fact would violate several provisions of the UDC along with Arizona statutes and case law. This board should be equally committed to the fair and correct result. There is no deference where the zoning determination was based on so many errors and with no evidence. All the legal reasons are spelled out to require the board to reverse the determination. But let's put all of the legal mandates aside. It's also abundantly apparent that the zoning administrator never considered the purpose of the UDC in making this determination. Since beginning operations, the downtown dispensary has made steady improvements in the neighborhood and at its own expense relocated an unsightly used car lot to address patient parking. The Santa Teresa Tile Works and the downtown dispensary have had a harmonious coexistence for many years, and the department considered no evidence other than the falsities planted by Mr. Crawford and Prime Lead. And it considered zero evidence regarding the impact on the neighborhood and the community. The downtown dispensary has benefited the community and will continue to benefit Tucson without needless and improper interference by its competitor. Its expansion is entirely within the already existing building and would just put unused space to good use, creating additional jobs in the community and producing more tax revenue for Tucson. It's sad that the zoning administrator did not even stop to think about the harm this decision would have on the downtown community when Mr. Crawford's agenda was pushed through. Members of the board, the city has received over 400 letters of support of the downtown dispensary. The law may require reversal of the zoning determination, but the city of Tucson demands it. I understand we don't have time to go through all of them. I've highlighted a few in this presentation for the board to take a look at, and a copy of this PowerPoint has been provided as part of the record. I won't spend the time to read these, but the people who the board serves, they've spoken. The only person here today in opposition to the appeal is Mr. Crawford. Now, there was a mention of a variance a couple of times. This isn't about a variance. This is about the fact that we meet all the legally required setbacks. What I would ask the board to do in conclusion is listen to the law, listen to your community, listen to your conscience. Don't allow Tucson's government officials to be improperly influenced, especially where it so clearly harms the community that you all serve. And I'm happy to address any questions the board has.
Yeah, I have one question, then I'd like to move on to other parties. And that is, did I hear you correctly some time ago within your presentation, saying that you did receive or obtain a permit from the city of Tucson for the expansion area?
Permits were received for the expansion. My understanding is the only thing that's left is issuing the certificate of occupancy. The only thing holding that up was getting this compliance approval, which was denied on the basis that the commercial art studio is now suddenly a school, even though it hasn't been for the last 9 years. And so we couldn't get that compliance.
So
approval.
do you have your permit in hand that you could show by way of the your presentation?
The permit is part of the record. I do not have it within this PowerPoint, but maybe while some other folks are talking, I can get that together and we can share it.
Okay, because we, I believe we're told otherwise by the city, but I'll confirm that with the city directly.
Thank you, Mr. Chair. The one thing I point out is permits were issued for the construction. I believe what the city is referring to is a zoning compliance letter for the marijuana use had not yet been issued, and that's what the holdup has been.
Okay. All right. Well, you gave us a lot to chew on. That was very voluminous in material and information. we have spent nearly an hour, so I want to move on and ask, well, I should ask the other board members, which I'll do now. Do any of you
Mr.
have
Chair.
any questions of the petitioner?
Excuse me, Mr. Chair, may I offer a rebuttal either now or after questions are received from other board members for the appellant?
Certainly. If you want to do that now, that would be appropriate.
Okay, I will attempt to address some of the concerns and items that were brought up by the appellant during his presentation. I apologize if I missed something, as there was quite a bit of information in there. I will refer back to the original determination dated March 18th, 2022. The question that was asked for the determination was whether the facility operating in Santa Teresa Tile Works would be considered a school. The original request was that it was neither a school and that a prior determination set a precedent. Those were the two questions that were asked to the zoning administrator, myself, and were which the subject of the determination. Again, I will repeat some information that you've heard already. The UDC does authorize the zoning administrator to make a determination on a use when it is not specifically defined. This can be found in UDC section 11.2.5. Art studio is not a defined term on its own. It is referenced in another category, as Mr. Callahan attested. I would not consider that to be a defined use as an example. So in this case, to determine the use for art studio, the standard practice is to use acceptable dictionary or other sources. In this case, Merriam-Webster dictionary defines art, which I will not read, it is in the determination, but it also defines a studio as the working place of a painter, sculptor, or photographer, and a place for the study of art. Therefore, in the determination, you will see that having a C of O or certificate of occupancy with the term art studio specifically allows for the study of art. It does not need to be a separately defined use of educational on the certificate of occupancy to allow for the study of art, because that is defined as part of the accepted use. The appellant, Mr. Callahan, specifically brought up a lot of history regarding the downtown dispensary and prior permits that were issued over the years. I'm not going to contest any of that information because that is not the question being asked of the board. The question being asked of the board is whether the determination is accurate, which was again a question of whether the use of the Santa Teresa Tile Works qualifies as a school. Much information was given to you regarding the certificate of occupancy as a source of information and a reliance of facts. In the determination, you will see it is not the only source that was used to reach the conclusion. Aside from the definition that I have already mentioned, I did have conversations with the head of school of Imago Dei. This is referenced in emails that were provided in the materials. There is specifically an email dated towards the end of December that was provided by the appellant because I provided it as part of a public records request, on which I said we talked a few weeks ago about the functions of Imago Dei at Santa Teresa Tile Works. That email record signifies the time that I did spend with Mr. Taylor, who's the head of school, clarifying the use of Santa Teresa Tile Works. The terminology for Arts Campus, which you will see referenced in numerous occasions, was provided to me directly by Mr. Taylor in conversation with him. No one is contesting, but I will repeat, Imago Dei has in its status Santa Teresa Tile Works as a nonprofit subsidiary of that school. Students do attend classes there on a regular basis. It is part of their normal curriculum. It is scheduled. These are not field trips as contested by the appellant. They are courses taught by both the Santa Teresa Tile Works employees and Imago Dei Middle School staff. Again, that is another source of information in the determination aside from the C of O. So in the determination, I reached the conclusion that the educational land use activities occurring at Santa Teresa Tile Works by Imago Dei align with the definitions in the UDC because education for grades K through 12 is being conducted on a regular basis on the site. I will repeat also that I relied on the facts as presented by the head of school, Cameron Taylor, for Imago Dei. I did not rely on facts from any other sources. You will see in the records that there are numerous emails that have been cited between myself and Mr. Crawford, who is another business owner in the area. And if you choose to review those emails yourself, you will see that I am very courteous to Mr. Crawford as he emailed me a few times. I said, thank you for your email. And I proceeded to do my review for the case in question outside of any influence from Mr. Crawford. I will also point out that there are a few mentions have been made regarding ARS or Arizona revised statutes that the primary function of the facility must be an educational use. That is not true. The statute of ARS is not required in this case and is not relevant to a marijuana use. The statutes that are relevant, I have provided in the determination. And two last points that I would like to make are one, regarding the state of the business or the state of the building or the status of what functionings are happening in other parts of the building. That is not the question being put before the board. The question is the determination and whether it should be upheld or not about the functions of Santa Teresa Tile Works and Imago Dei Middle School. Lastly, there's some question about the permit status. There were 2 permits that were applied for in the downtown dispensary or their proposal in July of 2021. The first was for a stair enclosure and lighting work. That permit was issued. You can see in the exhibit to the staff report, it specifically states stair enclosure and lighting. It states that on the permit, it states that on the stamped plans. No mention of any kind of an expansion is in that permit. The second permit was for an expansion. It was denied multiple times by zoning staff because of the lack of the zoning compliance. No permit was ever issued.
Ms. Hamlin, are you there?
Mr. Chair, I apologize. My computer just died as I was stating the last bit of information that I'd like to share with the board. That concludes my rebuttal of this.
Could you speak a little closer to the microphone?
Sure thing. I apologize, Mr. Chair. My computer died just at the very end of my statements. I did not have anything additional, but I'm open to questions from the board as needed. Thank you.
Okay, well, thank you for all that. Any board members have a question for Ms. Hamlin? Mr. Pagney, why don't you?
Yeah, I didn't.
Question. Go ahead.
Proceed. Sorry. Yes, I didn't have anything for Ms. Hamlin, but I just wanted to address the appellant on 2 issues.
Go ahead. Now,
Okay, the first.
Yeah, go ahead. And I was just going to say, this is sort of out of any order because I thought we would get through all the other parties and then come back. But why don't you proceed?
Sure, just a couple of points. One, just the beginning assertion of that this is something in the zoning administrator's character that caused this isn't really appreciated. I guess I would appreciate if you would just leave conspiracy theories about why this happened out of the conversation, just deal with the facts. And then, yeah, I think that's it for now. I've never, oh, sorry, I'll just point out that I've never met Ms. Hamblin in my life, but the idea that an administrator or someone would do this, maliciously, I think is really unjust. So thanks.
Okay, thank you. Any other board members with a comment or question, more particularly to Ms. Hamblin?
Mr. Chairman, Jesse Lugo.
I think I saw a hand first, Ms. Schubert, and then we'll come to Jesse. We'll get to you after.
Thanks, Chair Marks. I was just interested in the point of contention about the UDC definitions, and it sounded like there's maybe another UDC category that specifically includes art studios. I was just interested in getting a little bit more detailed information about why the determination was made for one UDC versus another.
Okay, and let's ask Ms. Hamblin that question, but are you concerned about the distinction between an art studio and an art class component to a school? Is that are you getting at that or no?
No, it was more about did the question that was raised was did the zoning administrator select the appropriate UDC definition in terms of the building use? The point was made that an art studio encompasses educational activities, so it's not necessary to have a separate designated educational use specifically, but there was a point raised during the presentation about the fact that there is a specific UDC definition that more closely applies to art studios.
Okay, well, let's ask Ms. Hamblin that. Ms. Hamblin, you understand the question?
I do understand the question. So in the presentation from the appellant, they referenced another defined use in the UDC, which I will read to you. It's titled technical service. And the definition of technical service is service of a technical nature provided to businesses and individuals. Typical uses include printing establishments, blueprint companies, photocopy companies, commercial art studios, recording studios, and computer access centers. So the question is whether the C of O that had the terminology art studio is already defined in the UDC under this category of technical service. I do not believe that it is because of the first statement under technical service, which is service of a technical nature provided to businesses and individuals, and that it includes some example type uses. I do not consider Santa Teresa Tile Works and the operations and the classes and the things that they provide there to be service of a technical nature provided to businesses and individuals. So therefore, the first clause in that definition is the deciding factor, and why I looked outside of the UDC for a definition of art studio that aligned with that certificate of occupancy.
Okay.
Thank you.
Ms. Lambert, you're fine with all that? You're good with that? Okay, thank you. Thank you, Ms. Hamblin. Mr. Lugo, you had a question of Ms. Hamblin, right?
Yes, I do. I just want to be clear. So the motion to uphold will be to deny the variance request. Is that correct?
Well, we're not talking about a variance. We're talking about the zoning determination.
Okay, then I retract my question then for.
Okay. Any other questions for Ms. Hamblin at this point? Okay, let's move on. Mr. Callahan, I presume you've wrapped it up, and for now, other than any rebuttal, which you'll be afforded the opportunity to do at a later time, I want to move forward and ask, are there any other parties that wish to speak? And I know that there were a large number of people that signed the petition. I am crossing my fingers we're not talking about that kind of number that wishes to speak in favor of the request. But if any party wishes to speak, I'm asking that you keep your comments down to no more than 3 minutes. And would you identify yourselves? I am not hearing anybody.
We
I-
do have a hand raised. We have a couple hands raised.
I'm looking for hands. Oh, well, I do see two. And based upon comments already received, I'm assuming Mr. Crawford is in opposition. Let me go to Ms. Kent and see if she is in favor. And could you turn your audio and your video on?
You instead.
Hello, I'm sharing a computer with Mrs. Kent, but my name is Ezra Talley. And I had some questions and concerns regarding this usage of this tile works
Let me
facility.
ask you, could you raise your right hand? Can you swear to tell the truth, nothing but the truth?
I do.
Okay, could you state your name and address?
Yes, my name is Ezra Talley. I live at 310 West Mojave Road in Tucson, Arizona.
Okay. And generally, are you in one of the two camps, in favor or opposed?
Absolutely. I am in support of the downtown dispensary's appeal. My concern is I don't see how, I've never heard of a school before where people can be on premises consuming alcohol, and then the school posts about it on their social media and stuff. It just seems like, I don't understand how there could be any way that this place could be considered a school with, such activities taking place regularly. Next door to two different bars, and there's a bar sign with a Miller High Life on the front of the building, but it's a school. It seems like a real conflict there. There can't be both. It seems like it has to be one, or should be one or the other.
Okay.
And it seems like it's not a school to me.
Okay,
Clearly.
that concludes your comments?
Yeah, basically. It seems
Okay, I
self-evident.
appreciate that. Okay, let me move on. And I see Natalie Beckley. And are you in favor of the request?
Yes, I am. I'm in favor of the appeal.
Okay, why don't you raise your right hand and you swear to tell the truth, nothing but the truth?
Yes, I do.
And could you state your name again and give us your address as well?
Natalie Beckley, 3051 East Winter Haven Drive in Tucson, Arizona, 85716. I have a concern about the percentage of time that it is being utilized as a school. I feel like that should be considered in the determination of whether or not it is a school. And then just as an additional comment, I'd like to say that over the last year, the downtown dispensary has added 108 jobs to the Tucson community. If we are allowed to expand further, we would be able to add even more jobs to the economy and also bring in more tax revenue. I think that is something that should be considered for this appeal.
Are you an employee of the dispensary?
Yes, I am.
Okay, okay. Well, thank you very much for your comments. Let me move to, there's an S. Hayden.
Yes, sir, that's me, Hayden Sauceda.
If you would mind raising your right hand, do you swear to tell the truth, nothing but the truth?
Yes, sir.
And could you state your name and address?
My name is Antonio Hayden Sauceda. My address is 437 South El Paso Avenue in Barrio Viejo here.
Okay, okay. What are your comments?
My comments is, especially myself being Latino here in the community and, being a resident of Barrio Viejo, a Latino community here, so close in relation to the downtown dispensary. I can attest to every day, the interactions we have with our community and how important it is for us in the community, especially me being a Latino, in this position that I am, is to connect with our community. And something since I've been employed here, because I am an employee as well, I've noticed how our connection with the community has made a difference on a personal level and in my neighborhood personally, because South El Paso Avenue is right next to the TCC. So not even a mile away from my home is this dispensary. And it's made a positive impact on my life. Sorry.
Okay. Okay, thank you very much. Okay, we'll wrap that up. Let me go to the next one. I see a Jonathan Fletcher. Would you turn your video on, your mic on, and raise your right hand? And
Chair?
do you swear to- are you there?
Yep, I'm ready.
Do you swear to tell the truth, nothing but the truth?
Absolutely, I swear to tell the truth.
And could you state your name and your address?
Yes, my name's Jonathan Fletcher. My address is 6245 North Carapan Place, Tucson, Arizona, 85741.
Okay, why don't you proceed?
All right. I did have just one question. I'm really kind of just confused how, if there's two existing bar properties and a dispensary across the street, how you would process a new school license unless it's a special exemption. But I guess the greater concern is if we're going to apply special exemptions to small use facilities where you're only being used part of the time, then by that definition, you could literally classify just about any place where you go to study or learn as a school, which would definitely kind of delegitimize the whole process of school zoning.
Okay. Okay, well, thank you very much. I'll move on, and I think we've already spoken to S. Hayden, right? Your hand is still up. I don't see any hands other than Mr. Crawford. And so how you were referred to before leads me to believe that you are not in the same category, but why don't you speak for yourself? Mr. Crawford, can you turn your mic and audio on?
Yes, sir.
And can you raise your right hand? Do you swear to tell the truth, nothing but the truth?
I do.
And could you state your name and your address?
Yes, my name is Michael Crawford. I live at 1900 North Fremont Avenue in Tucson. I also own the property that the Santa Teresa Tile Works building is located in.
Okay, yeah, that's something I didn't know. I don't know that any of the board members knew before.
Sure. I'm sorry, go ahead. Yeah, and I would ask for a little leeway on time, given the amount of time that was given to Mr. Callahan and the disparaging remarks he not only made about me, but Ms. Hamblin. There's been a lot said about me and my motivations and so forth. First of all, I'm not the CEO of the Prime Leaf. I am part owner of a management company that works with the Prime Leaf. So I'm not a CEO. I've never claimed to be the CEO. The reason I notified the city of Tucson about Mr. Asnani's business and his intention to expand, and the fact that there was a school parting instruction across the street, had to do with the fact that he did the same thing to my business. Mr. Lugo is, I think, the only person on the board currently that was present back in July of 2019, when Mr. Asnani had one of his employees he's on the Zoom as well, Mr. Stoker, file a complaint with the zoning administrator saying that they should not have issued a permit for our new building that we were building on 1525 North Park Avenue. And just to clarify, when you apply to do something like what Mr. Asnani is doing, the first thing you do is apply and get the zoning approval saying, yes, you can operate a marijuana establishment at this location, which we did at our park location before we bought it. We did it during construction. We got a construction permit. We built our facility. Right when we were getting our C of O, Mr. Asnani had his employee, through the same law firm that's representing here today, file a complaint with the zoning examiner saying you improperly did that there's a church near you, a Buddhist church, and then there was a drug and alcohol dispensary close to you, and also a school. Okay, can I share my screen as well? Is that possible?
Can you repeat that?
Can I share my screen as well?
You can, but let me ask you to keep your comments directed at the subject at hand. It's the
Sure.
dispensary's
That's fine.
operation specifically related to the expansion and the
Sure.
denial by the city of.
Well, I just wanted to try to clarify the comment about karma. And the reason I said karma in my email to Ms. Hamblin when I did is because what's happening right now to Mr. Asnani and his operation, he did to my operation 3 years ago. He filed a complaint with the state claiming that there was a school within 500 feet of our location, even though the city had already determined that there was no school within 1,000 feet of our location.
Mhm.
That delayed us getting open almost a year for him to do that. And
I'd
Chapel
like
Haven
to
West and so
keep
forth.
this separate from and I don't consider that.
Well, I understand that, but I was disparaged and claimed about using karma and all this other stuff by his attorney. He's also sued me. He's also sued Imago Dei or sued Santa Teresa Tile Works. And what I'll tell you is the reason I notified them is because there was a school imparting instruction 100 feet from their operation. And what Mr. Asnani said in a news story back then was all he wanted was the zoning laws applied fairly and equally to everyone. And that's all I'm asking for. I notified Ms. Hamblin because I found out she was the one in the city that would make those determinations. I gave her the information about who she could contact. I've never met Ms. Hamblin. I've never spoken to her on the phone. The only communications I've had with her were through the email communications. And I asked her about other information as well. So to impute her character and to impute my character with regard to that, I mean, as far as I understand, she's a very professional person. If you look at her reasoning and her decision, it's very sound. It follows what the law is. And again, if you look at not only what she interpreted with regard to the city ordinances, if you look at the state regulations and ordinances, also, and by the way, that's the only setback the state requires, is that you have to be 500 feet from a public or private school. And they define private school as a location where instruction is imparted. That's it. And it's clear based on her investigation, Ms. Hamblin's investigation, that Imago Dei Middle School conducts classes on a regular basis in my building, which is 100 feet from the downtown dispensary. They can continue to operate like they are. And by the way, I just wanted to point out one thing.
Okay, but I want you to wrap it up because we're running over.
Sure. Well, let me just two very important points. First of all, the business, Santa Teresa Tile Works business and the nonprofit didn't take over the operation until roughly 2019. So that's why this liquor license issue that's come up is just really a red herring and a moot. That would have been after all the other liquor licenses has come up. So they didn't actually obtain it until roughly 2019. And I will tell you, in the answer that they filed in the lawsuit that Mr. Asnani had brought against them, they state, and by the way, this is an attorney filing a document in their answer, the Santa Teresa Tile Works Imago Dei Middle School, an Arizona non-for-profit corporation, which does utilize the premises at 440 North 7th Avenue as part of its art campus where art classes are held. That's all that's what Ms. Hamblin found. Now, you can ask the city attorney to clarify, a zoning examiner's determination with regards to this there's a presumption of validity. So you all as board members have to presume that it's valid. The only way to reverse her decision is to determine that she acted arbitrarily and capricious. And there's no way that you can make that finding after reading her well-reasoned opinion and the staff report that was out there. She did everything which she was required to do that. You may personally not like the outcome, but the law is the law. If Mr. Asnani doesn't like the law, he can go try to change the law. But the zoning examiner did what she was required to do under the current law and under the interpretation that she found. And I think that it's, again, what's good for the goose is good for the gander.
Okay, thank you, Mr. Crawford. That last part was very clear. Well, let me see. There are a couple of other hands. Adriana Tyson,
Yes.
could you turn on? Okay. Could you raise your right hand? Do you swear to tell the truth, nothing but the truth?
Yes, I do.
And could you state your name and your address?
Yes, my name is Adriana Tyson and I live at 5491 North Indian Trail Road, Tucson, Arizona, 85750.
Okay, so what do you have to say?
I am proud to say that I have worked for the downtown dispensary since August 20th of 2013. And we have had a great relationship with all of the different businesses around us, including Santa Teresa Tile Works. And what I would like to do is shed some light on what that additional space will do for our business and for our community. At the downtown dispensary, we are helping our community and patients as well as customers now come off of opioids and narcotics and live a better life and be better members of our community and lead more productive lives. This to me is very important. And again, I'm proud to say that I've worked for the downtown dispensary for 9 years now. And knowing that we have had a good relationship with Santa Teresa Tile Works is just mind-boggling to me to understand how we have allowed this situation to happen and how this has come about. So I just want to, again, shed some light on the space, how it would allow more jobs for our community and help more members of our community. And that is something that we are really trying to do with this additional space.
Okay, thank you very much. Let me move on to Mo Asnani. And Mo, if you can turn your video and your audio on, and please, after we swear you in, avoid repetition if you can. If you can raise your right hand, do you swear to tell the truth and nothing but the truth?
I do.
Okay, why don't you state your name and address and then proceed with your comments.
Mohit Asnani, 250 North Meyer, Tucson, Arizona, 85701. I think the first thing to start off with, I don't want to get into all the old things going on, something for the Board of Adjustment to think about. When you start to call something a school, look for a certificate of insurance saying that it's a school. Otherwise, if something happens in a building with pizza ovens, electric kilns, commercial quantities of alcohol, and a few children there, hopefully not more than the occupancy limit, which would be 5 if it was any educational use, then maybe the zoning administrator should have said, hey, do you have proof of insurance at least saying that this is a school? Because if not, what the Board of Adjustment may do is put the city of Tucson in a legal position of that being a school if something happens, and then taking on the financial liability for that. I don't believe, and again, if Ms. Hamblin or even Mr. Crawford, since he's a property owner, want to produce a certificate of insurance for school use, and I know a lot about insurance because I'm in the cannabis industry and we have to have insurance out the wazoo for everything. So if a school that's going to have children in a building doesn't meet insurance requirements and bad things happen, does the city want to say, oh yeah, we'll take the fall for this, we'll take the blow for this, even without seeing private insurance certification for it? Again, there's other statutes that weren't mentioned necessarily regarding, the sex offender distance and all of that. But I think from a safety perspective, it just simply makes sense to say we should at least have the electric kilns and those types of places having fire suppression systems if we're going to have children in a building. This is all a little surreal, being there for 9 years and having to deal with this now. But we are doing it, and I will sing for my supper. I'm a first-generation immigrant, and my business partner is a U.S. Army veteran, and we're doing this. We started with 3 employees. Today, we have over 225 employees at 3 facilities in the city of Tucson. No loans, no third-party investment, nothing significant, rather. And that we've done that organically, creating jobs here after I graduated from Eller in 2005. So please, do the right thing. Thank you.
Thank you. I see one more hand, and that is Sebastian Barajas. Can you
Yes.
turn on your video, and do you swear to tell the truth, nothing but the truth?
I do.
Okay, could you state your name and your address?
Absolutely. My name is Sebastian Barajas. My address is 3454 North Tres Lomas Drive, 85749. I'm also one of the employees at downtown, and to kind of piggyback off what Mo said, you know, it really is something that came organically, and we are not using our full space. And just looking out right now, there's no middle school children. There's no slow down signs. And it's just rough to think that in our operation here, you know, we just can't expand because of that. And I just wanted to plead with the board to, you know, take into consideration that we have been up and running for a while now. So why stop us now? But yeah, I'd like to yield the rest of my time because I feel like you guys have said pretty much everything else.
Okay, well, thank you for saying what you did say. Let me turn to what I believe is the last hand. And that is not an individual, but it says downtown and D2 print. Could you identify yourself? Turn your video on and your mic on, and do you swear to tell the truth, nothing but the truth?
Yes, I swear to tell the truth and nothing but the truth.
Can you state your name and address, please?
My name is Christopher Tyler, and I stay 9000 East Speedway.
Okay. What do you have to say?
So what I have to say is I'm actually new to Arizona, Tucson, Arizona. I've been here for about a year to 2 years now. And me first moving to Arizona, I'm not gonna lie, I had trouble looking for jobs. I applied to about over 20 different jobs out here. And downtown in D2 was actually one of the jobs I had applied for. And out of all the jobs that I applied for, the first ones that hit me back was downtown in D2. And they brought me on to their company. And so far I've been liking it. I love it. It's made a big difference for me and my family. And it's been growing ever since. And there's more to come. I say it should be approved.
Okay. Well, thank you. Thank you very much. I think that completes all of the speakers. If I am wrong, let me know, but otherwise I want to go back to Mr. Callahan and give him another amount of time, a minimal amount of time to rebut the comments that have been made that are negative towards his case. And then I want to wrap the hearing up and get into matters before the board. So, Mr. Callahan, can you provide your final rebuttal? Mr. Callahan, we are not hearing you. I do not hear you. No. No, it was working the first time you spoke. I have a question for Mr. Castro and Ms. Galinsky.
Can you hear me now?
Yeah, I do.
All right,
Yeah,
excellent.
yeah.
For some reason, I had to leave and come back in. You're just restarting the computer, sometimes that addresses.
Okay, no, I hear you loud and clear.
And I could hear everything that was said, and I appreciate the brief rebuttal time, Mr. Chair. First, I want to point out, it is not a merely arbitrary and capricious standard. There is legal error here, and that is reviewed de novo across the board. If the statutes and the laws and the rules aren't interpreted properly, they need to be. And it is not this building, this Tile Works facility, it is not a K through 12 public, private, and charter school. And a K through 12 public, private, charter school is what it must be in order for the setback requirement to apply. The law does not allow the zoning administrator to broaden UDC 4.9.9.e.1J. Second, art studio is a typical example for technical services land use. There are specific certificates of occupancy for schools. This does not have one. It is a dangerous precedent to start calling businesses schools that have no public record of being a school. The case law clarifies, as we pointed out before, that it needs to be the primary function in order to qualify as a school for the purposes of these setbacks. Otherwise, as a lot of the public commentary noted, anywhere could be a school with the slightest evidence that, quote, instruction is imparted there. And that's not the law, and that can't be the law. Now, Ms. Hamblin said a few things. She said she got her information from Mr. Taylor when she stated that, quote, all art classes are held at Santa Teresa Tile Works. We know that's not true based upon what's been provided, that statement. And she has not addressed that the only evidence in the record, the written evidence that was provided, shows that Mr. Taylor told her that the general art curriculum is actually taught at Imago Dei, the campus well over 500 feet away from downtown Dispensary, not at Tile Works. Now, there was a question about why elementary school and secondary school was selected by the zoning administrator as the most appropriate use instead of technical services use. The zoning administrator, Ms. Hamlin, ignored the fact that the use at issue on this certificate of occupancy, it was certified 24 years ago before Imago Dei was even established. That's the use that's being interpreted, that certificate of occupancy use. The use was and remains a commercial art studio without any change of use over the last 24 years. Within the educational land use group is the instructional school use. And that's what Ms. Hamlin acknowledged and said included similar things like a dance studio. But in the zoning determination, Exhibit 1 of the staff report, Ms. Hamlin stated she did not consider it to be an instructional use. In terms of what we're focused on, and I'm not into conspiracies or anything of the like, I'm looking at the information before me and I'm seeing something wrong. And what I'm seeing is the disparate treatment of my client. The establishment that we're talking about today, Santa Teresa Tile Works, it doesn't qualify as a school for any purpose, according to the city of Tucson, other than to harm and negatively impact downtown Dispensary. It's not a school for the statutory requirements. It's not a school as far as the bar is concerned. It's not a school as far as sex offenders being required to register. It's not a school as far as the dispensary that's already there that's operating is concerned. Instead, it's only a school for the sole purpose of hindering the use of the existing building envelope for the downtown Dispensary. Now, who didn't we hear from today? We didn't hear from Santa Teresa Tile Works. We didn't hear from Mr. Taylor or anybody of the sort. We only heard from Mr. Crawford, who admitted this is retribution. He's upset with Mr. Asnani. He bought the property during this expansion process. It was literally while the expansion was going on, $1.4 million to buy that building and then begin lobbying the city of Tucson to take a position that it never before considered taking until Mr. Crawford asked them to. We ask that the zoning determination be reversed. Thank you.
Okay, thank you very much. I'm going to turn to the board members and say to you all that if there's any questions you have of Mr. Callahan or Ms. Hamblin or Mr. Castro, let me know and we'll do that right now. Otherwise, my intent is to close the hearing. So directed to the board members, do you have any such questions at this point?
I have no further questions for anybody.
Okay, thank you. Thank you, Mr. Dawson. I don't hear any from any.
I have one, Mr. Chairman Marks, I have one.
Then go ahead. And who is that to?
Okay, so this is, I'm directing it to City Council.
Ms. Glinsky, yeah, she is still here.
Let's verify that she's still on before I ask my question.
I don't hear her. I am going through.
I'm still here, Mr. Penny.
Oh, okay, so there is a
Yeah.
question for you.
Thank you. In making our determination, there were it was asserted during the conversation that we have to use certain language or have certain issues resolved to make our decision. Can you verify what what the board's decision is based on?
The statute requires that the Board of Adjustment determine whether or not the zoning administrator commit error in making her decision. And so you want to determine whether or not she acted arbitrarily and capriciously, in other words, without reason, in reaching her conclusion that the Tile Works functions as a school.
So the decision would have to be that we would have to decide that the administrator acted capriciously.
That she committed error, and that in so doing, she acted arbitrarily and capriciously.
Got it. Thank you.
Any other questions?
I have a question as well. So just point of clarification, when we come to a vote, we are supposed to avoid subjective decision-making at all costs. Is that correct?
Well, was that directed to Ms. Galinsky?
Anybody? I mean, just clarifying, because I think that we've heard a lot of evidence being offered to try to support overturning the zoning administrator's decision. Just as a point of clarification, it was my understanding when I got appointed to this board that we were supposed to avoid using emotions or subjective decision-making when coming to a determination. Is that
That's a good
true?
idea. I agree with that.
So this is a Piri. Mark, you may want to speak to that, but again, the motion template should be able to help you in incorporating the findings, which would be facts that you have determined have been or have not been proved. So that should help you to make a non-subjective determination.
So the scope within which we're looking is very clearly determined by the template.
Well, that includes the findings and the staff report. So you want to base your decision on the findings and the information in the staff report and information you've gleaned from the public hearing.
Thank you.
This is Mark Castro. We do have that motion template available. I also sent it to the board, but I can also put it on the screen if necessary.
Okay. Okay, Ms. Schubert, does that conclude your comments and questions?
Yeah, and I have the template, so thank you.
Okay, thank you. Any other questions or comments by any board members at this point? Hearing none, I am going to close the public hearing, meaning to all those out there not a part of the board or city staff, there's no additional input that we will take beyond this point. And it is a matter of the board members either discussing the subject or voting upon a motion made. So the floor is yours, and by yours, I'm referring to board members. It is your time to offer discussion if you wish, or to offer a motion.
Mr. Chairman, Jesse Lugo.
Yes, Mr. Lugo.
I move that we uphold the zoning examiner's determination related to case C10-22-05 for the following reason findings. That the evidence presented to the board shows that the use of the property address 440 North 6th Avenue does meet the definition of K through 12 public, private or charter schools as established through a certificate of occupancy as provided in the Unified Development Code, Arizona Revised Statutes, and Arizona Administrative Code, that art classes are held regularly with a private school which meets the criteria for educational land use as stated in the Unified Development Code and as established in the staff report pages 3 to 4. Therefore, for the purposes of applying the 500 setback requirement to a K through 12 public, private or charter school, the explanation of the marijuana dispensary must adhere to the Unified Development Code section 4.9.9.E.1.H and J. The appellant has no vested rights to the proposed expansion. No permit was issued for the facility expansion upon which the appellant determinedly relied as established in the staff report pages 5 through 6.
Thank you, Mr. Lugo. Is there a second to that motion? I'm asking the board, does anybody wish to second the motion that Mr. Lugo just made? The motion is not seconded. Is there?
Mr. Chairman,
Yeah, is there another
I'd like to make-
motion that you'd like to make?
yes, I'd like to make a motion.
Mr. Bagney, go ahead.
I move that we reverse the zoning administrator's determination related to case C-10-2205 for the following reasons finding. The evidence presented to the board shows that the zoning administrator erred in determining that the building at 440 North 6th Avenue does meet the definition of a school as defined in Unified Development Code section 4.9.9.E, .1.H, and J. And
I'm
given
sorry,
that-
point of order. This is Piri. There hasn't been a second on the first motion. Are you proposing a substitute motion, Mr. Pagney?
I am. I thought that Mr. Castro noted that the first one failed because it did not have a second.
That's true. Okay, thank you.
Completing my statement. And given that does not trigger the setback requirement for the dispensary as indicated in Unified Development Code section 4.9.9.E, .1.H, and J.
Okay, is there a second to that motion?
I will second that motion.
That is Mr. Dawson. So there is a motion made to reverse the zoning examiner's determination. It has been seconded. Ms. Hamblin, can we have a roll call?
Michael Marks,
Could I pass on voting at this point and come back to me?
Bruce Dawson,
Aye.
Jesse Lugo,
No, the state statute is very clear, adhere to the law.
Kathy Kubish,
I vote aye.
Lee Pagney,
Aye.
Miranda Schubert,
Aye.
Michael Marks.
I'll vote no, but there are 4 votes in favor.
That's correct.
So that motion carries. The zoning administrator's determination is reversed. That completes that case, and that completes the hearing today. Mr. Castro, is there anything we need to do before we turn off our mics and depart?
Mr. Chair, there are no other items on the agenda.
Okay.
Thank you.
Well, thank you to everybody. We're going to close the hearing.
Thank you.